Good morning, Your Honor. My apologies. I was having issues with my connection.
And Judge, we can hear you, but it doesn't seem like we cannot hear you. Sorry. No, it looks like you didn't connect with audio maybe. Did you want to go ahead and just connect and try reconnecting? And it's not giving me the option to try and unmute you. I believe you'll have to disconnect and reconnect again.
Barnes, can I get muted again? Yep.
Ms. Clerk, how many Spanish speakers do we have this morning? This is Maria Davis, the interpreter.
I believe we have 2.
Okay, thank you so much.
Can everyone hear me?
Mhm.
Yes, Judge.
All right. We ready to get started?
Yes.
All right. Delgado is the first matter.
Delgado es el primero.
What does the state feels appropriate on this matter?
¿Qué es lo que la fiscalía piensa que es lo apropiado en este caso?
Your Honor, the state's not objecting to an own recognizance release for Mr. Delgado with no contact with the victim.
Su señoría, la fiscalía no se opone a que se le deje en libertad al señor Delgado bajo palabra y que no tenga contacto con la víctima con ese requisito.
All right. Any objection?
¿Qué? ¿Alguna posición?
No, Judge.
No, su señoría.
All right. The defendant's released on his own recognizance.
¿Qué? El acusado queda en libertad bajo palabra.
Obey all laws, no contact with the victim.
Obedezca todas las leyes y no tenga ningún tipo de contacto o comunicación con la víctima.
Make all court appearances.
Y preséntese a todas sus audiencias en la corte.
October 28th.
El 28 de octubre.
At 9 a.m. is the defendant's next court date.
A las 9 de la mañana es la próxima audiencia del acusado.
Thank you.
Okay, gracias.
Mendez and then Eddie.
Méndez.
All right. What does the state feels appropriate on this matter?
¿Qué es lo que la fiscalía piensa que es lo apropiado en este caso?
The state's requesting bail in the amount of $5,000 with the conditions of DAS with testing for controlled substances, no contact with LBC if he's able to post.
La fiscalía está pidiendo que se le imponga una multa de $5,000 con supervisión de servicios alternos a la sentencia, que se le hagan pruebas para detectar el uso de drogas o alcohol y que no tenga contacto con la víctima, que es LBC, en caso de que pague la fianza.
The defendant scores an 8 on the risk assessment. He was last released from the jail on October 1st.
El acusado tiene un puntaje de 8 en la evaluación de riesgo. Se le había dejado en libertad el 1 de octubre de la cárcel.
He has a suspended sentence out of this court, which was imposed on October 1st.
Tiene una sentencia suspendida que había sido impuesta por esta corte el 1 de octubre.
That was reduced from a DUI to a reckless driving because of a witness issue.
Esta había sido reducida de un DUI a un manejar imprudentemente por el hecho de que no tenían un testigo.
And that was a drug DUI case, Your Honor.
Y ese era un caso de DUI o manejando bajo la influencia por drogas, su señoría.
He also has a misdemeanor conviction this year for possession of drug paraphernalia.
También tiene un delito menor por posesión de artículos de droga este año.
He has quite a bit of criminal history between 2014 and 2024.
Él tiene considerable antecedentes penales entre el 2014 y el 2024,
Including felony convictions for attempted eluding in 2024,
incluyendo sentencias de delitos mayores o felonía por el intentar eludir en el 2024,
a felony conviction for possession of a controlled substance in 2018,
en el 2018 tiene un delito mayor o felonía por posesión de sustancias controladas,
felony convictions for four felony convictions for possession of methamphetamine and a felony conviction for unlawful use of a weapon back in 2014.
y también tiene cuatro felonías o delitos mayores por metanfetamina y por tener, y en el 2014 también tiene un delito mayor por tener en su posesión un arma cuando es una persona que no debería, no puede hacerlo.
Additionally, he has many arrests for failures to appear throughout his history.
Y además de esto, tiene muchas órdenes para su arresto a través de todo este historial por incumplimiento a comparecer.
For those reasons, the state's requesting bail in the amount of $5,000.
Por esta razón, la fiscalía está pidiendo que se le imponga una fianza de $5,000
DAS with testing if he posts a no contact with LBC.
y que tenga supervisión por parte del departamento alterno a la sentencia y que no tenga contacto con LBTC y también que se le hagan pruebas para detectar el uso de drogas en caso de que pague la fianza.
All right, thank you, defense.
¿Qué? ¿Por la defensa?
At this time, we're seeking an OR release onto DAS supervision with drug testing.
En este momento estamos pidiendo que se le deje en libertad bajo palabra con pruebas para detectar el uso de drogas o alcohol y con supervisión por el departamento alterno a la sentencia.
And looking at Mr. Mendez's criminal history, it looks like drug abuse is a substantial aspect and motivator of it.
Al ver los antecedentes penales del señor Méndez, vemos que el uso de drogas es algo bastante significativo en esto y una motivación para hacer esto.
I believe we can mitigate any danger to the community that Mr. Mendez poses with that random drug testing.
Yo creo que podemos mitigar cualquier riesgo que el señor Méndez represente a la comunidad con el hecho de que se le hagan las pruebas al azar para detectar el uso de drogas.
In lieu of a straight OR onto drug testing, if bail is to be ordered, we are seeking an OR release through inpatient treatment due to the prevailing drug issues in his history.
En vista de que si no se le concede la libertad bajo palabra, si se le va a imponer una fianza, nosotros en vez de la fianza pedimos que se le dé de alta a un programa sobre el uso de drogas en vista de que él tiene problemas con el uso de drogas.
And with that, defense will submit.
Y con eso la defensa termina.
All right, thank you.
Gracias.
On his pending case with our court that he's recently been sentenced on,
En su caso pendiente aquí con nuestro tribunal en el que recientemente fue sentenciado,
he had pretrial violations.
él tenía violaciones previas al juicio,
He failed to appear.
no cumplió con comparecer
And now, within weeks of receiving a suspended sentence in that case,
y ahora, solo unas semanas después de que recibió una sentencia suspendida en ese caso,
he's been arrested on these charges.
él ha sido arrestado con estos cargos.
We tried the defense's suggestion
Nosotros intentamos las sugerencias de la defensa
on the previous case, and it was not effective.
en el caso previo, pero no fue efectivo.
That's consistent with all the evidence on pretrial release.
Eso es consistente con todas las evidencias una vez que se le dejó en libertad bajo la supervisión de servicios alternos a la sentencia.
Drug testing alone with individuals that are high risk and high needs is not effective.
Solo el hacer las pruebas de las drogas en personas que son de alto riesgo y que tienen alta necesidad no es efectivo.
Treatment must accompany the testing.
El tratamiento debe ser acompañado por las pruebas para detectar el uso o consumo.
I don't know what level of treatment the defendant needs.
No sé qué nivel de tratamiento necesita el acusado.
Without that information,
Y sin esa información,
I must set bail in order to protect the community
yo debo de imponer la fianza para poder proteger a la comunidad
and ensure the defendant's presence at court.
y asegurarme de que el acusado se presente en la corte,
Because I find the state shown by clear and convincing evidence that that's necessary.
Por lo tanto, es mi decisión que la Fiscalía ha mostrado pruebas claras y contundentes de que esta fianza es necesaria.
Bill will be set at $10,000.
La fianza va a ser fijada a $10,000.
I'd ask the clerk to set an order to show cause in the Department 2 60-day jail sentence case.
Y le pido yo a la secretaria judicial que fije una audiencia para mostrar las pruebas en el departamento 2 en el caso que tiene en la cárcel dentro de 60 días.
If the defendant obtains a substance use disorder evaluation,
Si es que el acusado obtiene una evaluación sobre el uso de sustancias controladas
and someone can arrange for the treatment as recommended,
y alguien puede hacer arreglos por ese tratamiento de la manera que se recomiende,
I will reconsider the bail decision and strongly consider a known recognizance to treatment and testing.
entonces yo reconsideraría la fianza y consideraría el que se le deje en libertad bajo palabra, pero dándosele de alta hacia un lugar para el tratamiento.
Until then, the defense next court date is October 24th at 9 a.m.
Y hasta entonces, la próxima fecha para la otra audiencia del acusado es el 24 de octubre a las 9 de la mañana.
Thank you.
Gracias.
I believe that's all the interpreter matters.
That is correct, Judge.
Okay, thank you so much. Thank you, Judge. Have a good day. Thank
You
you,
too.
everyone. Thanks.
Thank you.
Thanks.
Eddie? Sorry, it's Edie. Sorry, you told me yesterday, right? It's Edie?
Yes, I did, Your Honor.
I'm sorry. So
Okay.
this is continued from yesterday at my request. I
Okay.
wanted to learn a little more about the defendant's criminal history, in particular, the risk she poses to the community for violence or felony theft related charges. What can the state tell me in that regard?
So what I can tell you, Your Honor, is with regard to violence and felony theft, what we've got is a 2002 felony arrest out of Kansas for forgery and theft with no disposition noted. Everything else, it appears to be failures to appear and drug related.
All right. Miss Edie, where do you live?
What do you say?
Where do you live?
Oh, I live here in Reno.
Okay.
Uh,
Go ahead.
My
Well, I just
285
want to know generally, are you on the bus route? Can you walk? How are you going to get to court?
Oh, I'm taking Access, and I take the from Access. I get on the main buses now.
Okay.
I'm learning the
So you have
trails.
the ability to get to our court. Our court's 1 South Sierra Street. It's right on the river. Okay.
Yep.
You know where it's at?
Yeah, I take my Access from my apartment. I order a ride, and then I catch on the regular city transit 7 out to 4th, and I 4th I get walk there.
Okay. I'm going to give you a chance, but you're only going to get one chance. Okay.
Thank
If you
you,
don't
Your
show
Honor.
up to court, then I'm going to have to put you back in jail, and I don't want to do that. Okay.
Thank you, Your Honor.
So your court date is going to be a week from tomorrow,
Okay.
Monday the 27th at 9 a.m. Now, what I want you to do is come down to court tomorrow and check in
Okay.
with us, because we have the
Yes.
ability to give you, remember I told you 1 South Sierra Street.
Yes.
All right. We have the ability to text you and give you reminders. So I want you to make sure I want you to show up tomorrow at our court, Tell them the judge said I needed to come in and make sure you have the right phone number so you can get a hold of me. That also allows you that if something happens, you can appear like this by Zoom on your phone or somebody else's phone if for some reason you can't make the bus that day. Okay?
Okay. Excuse me.
It's okay. So you'll show up to our court tomorrow before
Yes, sir.
noon and
Yes,
make
sir.
sure we have the right contact information for you so that we can make sure you show up to court, okay?
Yes, Your Honor.
You also, of course, have to obey all laws and show up to all
Yes.
your court proceedings, okay?
Yes, Your Honor. Thank you.
Show up
You're-
tomorrow, but that's your next work date as well.
Okay. Thank you.
OR, obey all laws, make all court appearances.
Okay, thank you.
How about Pato and then Butler?
Good morning, Your Honor.
Morning. What the state feels appropriate on this matter?
So, Your Honor, we continued from yesterday for victim contact. We weren't able to get in touch with the victim. However, the co-offender in this case, she pled guilty to robbery back in August. I believe she's set for sentencing on Tuesday, and that was for her involvement in this case. The parties are jointly recommending 28 to 72 months in prison. I would just note for the court that she has no prior felony convictions, unlike this defendant, and I'll get into that in a moment. But that just kind of gives the court an idea of how the state values this case. But my point is, I looked at her PSI to see if the victim made a statement in that case, and he did. He indicated he is still fearful of the co-offender and her associates, so much so that he left the state following this robbery and stabbing. So the state's requesting bail in the amount of $250,000, bondable only, DAS with testing for controlled substances, no contact with the victim, house arrest with GPS, and no firearms. Of course, if the court intends to do a 10% option, my request would be much higher. So he scores a 9 on the risk assessment. He's got 2 points for violent criminal convictions, 1 point for felony convictions, 1 point for misdemeanor convictions, and he was released from prison in May. So he's got a pending felony case right now. He's got an October 15th arrest for possession of a credit card of another, possession of a controlled substance, 2 counts of that, resisting, and possession of drug paraphernalia. It looks like his bail was set in that case at $5,000 on the 16th. He's got a felony conviction for grand larceny of a firearm in 2024. I believe that's the case for which he was just in prison. Misdemeanor conviction for battery back in 2022. And he's got a 2020 felony conviction for robbery. He was also originally charged with attempted murder in that case, but it looks like that charge was dismissed. That's out of Sacramento. 2019, he's got a gross misdemeanor conviction for possessed dangerous weapon out of Second Judicial District Court. In that case, he had a failure to appear pretrial and his probation was ultimately revoked. Same year, 2019, he's got a misdemeanor conviction for resisting. So he's 25 years old. He's already amassed quite a substantial criminal history. Notably, he has a felony conviction for the same thing he's accused of in this case, where apparently some level of violence was used. The level of violence in this case is pretty staggering. The way they executed the robbery is pretty shocking. And so the state is requesting bail in the amount of $250,000. Like I said, I would request more if the court intends to impose that 10% cash option. DAS with testing for controlled substances, no contact with the victim, house arrest with GPS, and no firearms.
So what's the amount you would request if we followed the best practices and allowed the 10%?
So, Your Honor, the state would then request $1 million.
All right, defense.
Judge, at this time, we're seeking an OR release with appropriate release conditions. Looking at his MPRA, scored a 9, but in that 9, there was no prior FTAs, no multiple substance use arrests, and a verified phone. We were able to reach a reference for him as well. Was able to verify an address that he could stay at locally. We have no objection to the house arrest, the no contact order, along with DAS and testing. I think those are all appropriate given the circumstances. Outside of that, if the court is inclined to order some amount in bail, we would ask that there be an option for him to get into treatment once we have an evaluation on the books pointing to appropriate treatment. Because I think, again, the solution to any type of criminal activity that is catalyzed by drug use is treatment with testing. So with that, defense will submit.
All right, thank you. The state shown by clear and convincing evidence that bail outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. You know, the evidence is the bail bondsmen oftentimes don't even take 10%. So it's easier to get out on a bond than it is on a 10% option, according to most of the research. That's why our court follows that, and it's the ABA and the other organizations' best practices. Plus, there's many other problems with bail bondsmen being in charge of who gets out versus the court being in charge of that decision. So I don't think there's justification for jumping from $250,000 to $1 million. I do believe there's justification for bail outside the defendant's ability to make it. So it'll be set in this case of $500,000 or 10%. There will be no contact pursuant to statute for the maximum period of time. The house arrest causes a lot of problems. We've been told that that's one of the primary reasons DAS was going over budget, and has led now to the county dissolving the agency. So I don't know of an effective way to order house arrest at this time, because the county's not provided sufficient resources for that option. Obey all laws, make all court appearances. I'll order the random drug testing for the period of time that we have that at DAS. My understanding that's going away as well. So that'll be the order, and then I'll see the defendant back on October 24th at 9 a.m. With regards to why I didn't order the drug evaluation and treatment, the studies show 85% of the population at our jails in this country either were under the influence when they committed the crime or have a substance use disorder. Certainly treatment is the answer, but when you have individuals engaged in such violent criminal history, in fact, in this case, the Eighth Amendment, I think, clearly supports bail outside the defendant's ability to make it. As Justice Rehnquist said, bail is only excessive under the Eighth Amendment if it's excessive in light of the perceived evil. And in this case, the facts certainly justify and would not allow somebody who could simply walk away from treatment to that risk is not acceptable given the government's compelling interest in public safety. So that's my reason for not allowing the treatment option. Next matter is Butler. After that is Cassatt. What's the statement appropriate on this matter?
Thank you, Your Honor. So I believe we also continued this one from yesterday for victim contact. So I'm just checking one more time. Okay, so it looks like we've not been able to make contact, but the state's ready to go forward today. So my ask was going to be 150,000 bondable only, but I'll modify that since the court intends to impose that 10% option. I would request $300,000 DAS supervision if he's able to post, no contact with the victim, and no firearms. So Mr. Butler scores a 7 on the risk assessment. He was also arrested on a trespassing case. He's got a 2018 misdemeanor arrest for possessing a firearm while under the influence. There's no disposition there. 2013 misdemeanor conviction for minor in possession. Looks like he was also arrested for robbery and burglary in that case, but wasn't charged for either. He had a post-adjudication warrant issued in 2015, which remained outstanding until 2018. He's got juvenile history in California between 2007 and 2010, including arrests for burglary, unlawful taking of a motor vehicle, arson, robbery, vandalism, and threatened crime with intent to terrorize. He had bench warrants issued in 2009 and 2011 for failing to appear on juvenile matters. So while he doesn't have a whole lot of recent criminal history, Your Honor, this is a very serious shooting case. The evidence does appear to be very strong. And he does have substantial history throughout the course of his life, including failing to appear. So due to the risk to the community, the state is requesting bail in the amount of $300,000 DAS if he's able to post, no contact with the victim, and no firearms.
All right, thank you, defense.
Looking at the case, I do believe that bail would be necessitated based on risk to the community. However, I do think 150,000, 300,000 are well beyond even that, which is beyond Mr. Butler's means. He has no ability to post any amount of monetary bail. I'm just seeking that bail be set in the amount of, say, 15,000 bondable. Just given his score on the MPRA, also what he's reported to us, which is that he works 2 jobs locally. He's been in the area for the past 12 years, has a local address, 2 kids that he provides for as well. We weren't able to reach his reference for these points, but I do believe that Mr. Butler has significant attachments to our community and has that greater of a threshold to follow through with any ordered conditions on pretrial release if afforded that opportunity. So again, I'm seeking bail in the amount of 15,000 bondable, and defense will submit with that.
All right, thank you, counsel. The state shown by clear and convincing evidence that bail outside the defendant's ability to make it as necessary to ensure the safety of the community and the appearance of the defendant will be set as requested $300,000 or 10% cash. No contact with the victim for the maximum period of time allowed by statute, separate criminal offense for any violation. Well, bail laws make a court appearance. No firearms. And I'm going to add that condition to Avamto, the previous gentleman, and that an affirmative obligation of DAS to ensure there's no firearms in both cases if the defendants are released. So the defendant must allow DAS into their residence anytime that DAS requests to verify that they are not in possession any firearms in their dwelling or on their person, no firearms that they have access to in both of those cases. Now, when DAS goes away and we don't have the ability for officers to do that, then I may have to increase the bail, even if they are out without the ability to ensure the public safety. That'll be the order in each of these cases. Defendant's next court date is October 24th at 9 a.m. Kazat, and then Irwin.
That means if you post bail, contact with.
Kazat, and then Irwin. All right, was the state feels appropriate on this matter?
The state's requesting bail in the amount of $5,000 DAS with testing if he's able to post. He scores a 12 on the risk assessment with 1 point for prior felony convictions, 1 point for misdemeanor convictions, 2 points for pending case, 2 points for substance abuse. Looks like he was also booked on a failure to appear warrant out of Sparks Municipal Court. Looks like that was for failure to register as a misdemeanor, no insurance, and fictitious license plates. 2022, he's got a felony arrest for a probation violation, misdemeanor conviction for possession of drug paraphernalia, and misdemeanor conviction for failure to appear. Another failure to appear arrest in 2020. That was a felony failure to appear arrest. Fugitive arrest out of California in 2019. Felony conviction for uttering in 2018. His probation was revoked in 2022, and he was sentenced to 19 to 48 in prison. He's got a fugitive arrest in California, 2018. I think it was on that uttering case. 2014, a misdemeanor conviction for PCS. That was out of California. His probation was revoked in 2017. Felony conviction for burglary in 2013. That was out of California. There was dispositions noted. Well, there was notes in the file that said rearrested on warrant 9 times between 2014 and 2017. So it looks like that case went to warrant 9 times in the matter of a couple years. And then 2012, a misdemeanor conviction for PCS. Same thing, he was rearrested on warrant 3 times between 2012 and 2015. So he's a high risk of continued criminal conduct, high risk of failure to appear. So the state is requesting the $5,000 bail DAS with testing if he posts.
Thank you, defense.
Seeking an OR release with DAS supervision and random drug testing. While he did score a 12 initially on the MPRA, he had no points for prior violence and no points for prior FTAs. In addition to that, we were able to reach a reference for him who was able to verify his address and also his personal phone. Mr. Kazat also reports that he works with LaborMax, so common agency we find a lot of individuals working through. That would potentially move his score from a 12 to an 8. And then I'm seeking an OR based on the facts of this case. It's a very low amount of methamphetamine found on his person. In addition to that, there's no other indicia of ongoing criminal activity, at least nothing in a serious matter. So I do believe that OR with DAS supervision would be fair, given the facts of this case. Otherwise, defense will submit.
All right, since the employment's not been verified, he still scores a higher risk to reoffend or fail to appear. That puts him in the 50th percentile of being successful. That, and we also know that these types of charges, drug charges, have the highest incidence of failure to comply pre-trial. Therefore, the state shown by clear and convincing evidence that bail, even outside the defendant's ability to make it, is necessary to ensure the safety of the community and the appearance of the defendant. The other concern is that it's not just his use of a controlled substance, but the numerous burglary and felony theft related offenses that arise out of, I'm sure, his use. And without sufficiently controlling that use, he poses a great risk to the community. Given his criminal history, the facts and circumstances of his compliance as detailed by the state. So the bail will be $25,000 or 10%. With regards to conditions, again, I have no idea what is going to be available to the court. I can order DAS at this point, but that's puts me in the difficult position of when that no longer exists, of possibly reincarcerating the defendant because I can't minimize the risk. I will order he'll obey all laws and make all court appearances. And his next court date will be October 24th at 9 a.m. Irvin and then Scorsonelli.
All right. Judge, I've spoken with Miss Irvin. I would ask to waive her appearance and proceed with the bail hearing. I've also spoken with Miss Phelps prior to this bail hearing, and I believe defense will be submitting on her suggestion.
All right, what is that suggestion?
State, you're muted.
Sorry about that. Your Honor, the state would request $5,000 bail, DAS, if she's able to post and no contact with the pepper mill.
All right, $5,000, no contact with the pepper mill, bail laws, make all court appearances. Report to our court, Reno Justice Court, within 24 hours of release. Scorsonelli and then Huber. What's the state feels appropriate on this matter?
So if I may just have one moment, Your Honor. Oh, this is the traffic case. So this defendant has no prior documented criminal history. He scores a 6 on the risk assessment. Obviously, the facts of the case are concerning, his behavior, the way he was driving. But the state's not objecting to an unrecognizance release at this time.
I feel that's appropriate. So we'll see the defendant for an out of custody arraignment date. He's released on his own recognizance, obey all laws, make all court appearances. Come to our court and check in tomorrow to make sure we have valid contact information for you. Check in before noon. And then we're at 1 South Sierra Street. And then I'll see you on the 28th at 9 a.m. Huber and then Kuzbit.
Judge, I would ask to waive Mr. Huber's appearance, but we are prepared to proceed with the bail hearing.
All right, well, the state feels appropriate.
Your Honor, the state's requesting bail in the amount of $20,000, DAS supervision if he's able to post, no contact with the print shop lofts at 420 Valley Road. So Mr. Huber scores a 15 on the risk assessment. He's got 1 point for failing to appear, 1 point for violent criminal convictions, 1 point for felony convictions, 2 points for misdemeanor convictions, 2 points for having a pending case, and 2 points for substance abuse. He has a misdemeanor arrest from a couple weeks ago, October 3rd, for tampering with a motor vehicle. That case is still pending. He was released on his own recognizance on October 5th. So he's on pretrial supervision on that case. He's got misdemeanor conviction for intoxicated pedestrian on a highway this year as well. In that case, he never checked in with pretrial services, and then he failed to appear for his out of custody arraignment and a bench warrant issued. We didn't see him again until he was picked up on that tampering case, I believe. 2024, he's got a misdemeanor conviction for trespassing. Also in 2024, misdemeanor convictions for battery and trespassing. He's got arrests for failure to appear throughout his history. He's got misdemeanor convictions in 2021 for obstructing and trespassing, and then additional criminal history with arrests and misdemeanor convictions dating back to the 80s. So he's a very high risk of continued criminal conduct, high risk of future non-appearance. So the state's requesting $20,000 bail, DAS supervision, no contact with the print shop lofts at 420 Valley Road.
All right, thank you. Spence?
Judge, at this time, I'm seeking an OR release with no supervision conditions. I'm premising that on the fact that I do not believe that there's probable cause for the current charge, residential burglary, primarily because there's no evidence pointing to the sufficient intent requirement for that charge. It appears to be just simply a trespass, a strong, concerning trespass, but all the same, there's no facts pointing to the intent to either steal or batter somebody or assault anybody. So with that in mind, I'm seeking that OR release.
All right. State shown by clear and convincing evidence of bail, even outside the defendant's ability to make it, is necessary to ensure the safety of the community and the appearance of the defendant will be set at $50,000, 50, or 10%. No contact with the victim locational bail laws. Make all court appearances. Again, with testing and no effective way to respond to that testing, all the evidence is that there's no point in ordering that condition. And if I'm only going to have testing at some private lab and pretrial services officers that can simply file a violation report and no ability to effectively change the behavior, there's no sense in ordering the testing. Just be a waste of community resources. It's especially when there's no treatment accompanying it. So those will be the conditions. The next court date is October 24th at 9 a.m. Thank you. Kuzbit, and then Munoz Gonzalez.
Judge, just like with Irvin, I've spoke with Ms. Kuzbit. She would like to waive her appearance today. I also spoke with Ms. Phelps, and defense will be submitting on her suggestion.
All right. What is that suggestion?
Your Honor, the state would recommend $20,000 bail. DAS with testing would be my request if she's able to post and no contact with Alta. She's also in custody on some felony charges out of Sparks Justice Court, those being possession of stolen motor vehicle and use ID of another. She scores a 10 on the risk assessment. Defense is submitting. I can go through her criminal history if Your Honor would like.
I think the pretrial services report certainly justifies by clear and convincing evidence bail and bail outside the defendant's ability to make it with open cases in Sparks Justice Court, Reno Municipal Court, Carson City, and this court. The defendant's clearly a very high risk to reoffend, this being a felony theft related offense. Bail outside the defendant's ability to make it, it'll be $50,000, 50, or 10%. Bail laws make all court appearances. October 24th at 9 a.m. to defendant's next court date. Munoz Gonzalez. Defendant has two cases. What's the state's position?
Your Honor, the state's requesting a one-day continuance for victim contact.
All right, we'll see you tomorrow, sir. Harness and then Sing.
Good morning, Your Honor.
Good morning. So did we verify whether you have Warren Johnson representing you or not?
Sir, we haven't seen any attorney for the last 3 visits, so I think that I would like to be defended by the public defender.
All right. That wasn't my question. Have you been able to verify whether or not Mr. Johnson has been retained as your attorney in this case?
Sir, you asked me to make a call yesterday and I was not allowed because it was not my day to make a call.
All right. So you've not been able to verify whether
No,
Mr.
sir.
Johnson has been retained in this case?
No, sir.
Your girlfriend told you that she was going to or had, what was the language she used?
Sir, the only time I've been able to talk with her was the first day that I was here, and I haven't been able to use the phone since.
So, and what did she tell you with regards to whether or not Mr. Johnson was retained?
She did say that we had actually, she didn't say anything about an attorney because it was too early in this process. So I haven't talked to her at all
Why did you
about,
think then that you had him on your case?
because the public defender on Friday said that I did have an attorney.
Where did Orrin Johnson's name come from?
It must have been from Don Killeran, who they called to verify the information.
Have you had Mr. Johnson represent you before?
No, sir, I've never needed an attorney.
What is your financial ability? I'm going to have to swear you in. Go ahead and raise your right hand. Do you
Yes, sir.
solemnly swear or affirm under penalty of perjury that the evidence and testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, tell me what your weekly income is.
Probably $5,000, sir.
And this may seem like an odd question, but will you receive any of that while you're incarcerated?
Yes, sir.
All right. I can't appoint you the public defender. You have the ability to hire an attorney. It's unfortunate that the jail has not allowed you to do so. So your options are limited today, and you can represent yourself in this bail hearing, or we can continue this to tomorrow to allow you additional time to try and hire an attorney.
Sir, I would like to represent myself today.
Okay. What I want to caution you about is don't mention any of the facts and circumstances of the case. We're obviously, we have the prosecutor here, as you've seen. You've got law enforcement surrounding you. This is being recorded, and anything you say will be used against you. You saw you were advised of your rights by a videotape either this morning or yesterday. Is that correct?
On Friday, yes, sir.
Okay. So I strongly encourage you to not talk about it. You've seen how these hearings go this morning. The issue is, are you going to show up to court, and are you a risk to reoffend? And that'll be the limits largely of what the state's going to argue. And I would strongly encourage you to limit your arguments to that as well.
Yes, sir.
We have a risk assessment that was done in this case that indicates that you don't have any prior criminal history. You have no prior failures to appear, therefore. So that's already established in the case. You don't even have to talk about that. They have verified in that process your employment, your residence, your lack of, or your cell phone that we have to use to contact you, your lack of criminal history. So you don't need to spend a lot of time talking about that as well.
Yes, sir.
But the state has the burden, so they go first, and they actually get to go last if they want to as well. So after I hear from the state, I'll hear from you, okay?
Yes, sir.
All right, go ahead, Ms. Phelps.
Thank you, Your Honor. So commensurate with the other cases we've seen of this nature, the state is requesting bail in the amount of $10,000 with DAS supervision if he's able to post that, and I anticipate based on his income that he would be. And of course, the reason why, Your Honor noted, he scores a 0 on the risk assessment. He has no prior documented criminal history. But it's just the nature of these cases and the danger that it poses to the community, these types of cases like this. And I would also just point out that Mr. Harness seemed to acknowledge that he knew it was wrong to pay a 17-year-old for sex, and then he tried to do it anyway. And so for those reasons, the state is requesting $10,000 bail, DAS supervision if he's able to post that.
All right, sir. That $10,000, that only requires that you post 10%. $1,000 is all you're going to have to post. I imagine you'd be able to make that bail pretty quickly, but what else would you like to say?
That's all I need to say, sir.
Okay.
That's good.
All right, the bails as requested by the state, $10,000 of bail laws, no contact with any minors that aren't your family members. Make all court appearances. I want you to show up to our court tomorrow to verify. I'll give you all the way until we close at 5:30 to just verify yours. Well, let me make sure that is your cell phone number, the 250 number.
250-2668.
Okay, then just show up for your court appearance then, which will be October 28th at 9 a.m. at the Reno Justice Court. All right, we'll give you text reminders of that.
Yes, Your Honor.
All right, thank you.
Thank you.
Singh?
Good morning, Your Honor.
Morning, Mr. Singh, you indicated you were going to hire your own attorney. Is that still the case?
Yeah, but like right now, I don't have to think to call my family to let them know like that. But like right now, until I'm like over here, I will go with
You'd
him.
like to apply for the public defender? You would like to see if you qualify for the public defender?
Yeah.
All right. Are you having some trouble understanding me?
No, in between, I guess like.
Well, let me ask you this. Of the words that I've said today, not just here with you right now, but of the words I've said during the time you've been in that courtroom, what percentage of those words have you understood? 50%, 60%, 70, 70?
75, yeah.
75. So we're going to have to continue this for an interpreter. The law requires you understand 100% of what I say, actually. So
Okay.
we'll continue this tomorrow to get you an interpreter. Thank you.
What's your language?
My language is like Punjabi, but still like almost I grab the main things,
Okay.
grab the main words.
All right.
Yeah.
Thank you. We'll see you tomorrow. Is there anyone else up at the jail?
That is it, Judge.
And
thank
just to verify, Ms. Barrett, he said Punjabi, correct?
That is correct.
Okay, I will note the case. Thank you.
Thank you.
All right, everybody, enjoy this nice Sunday weather.
You as well, Judge.
Thank you.